Welcome back to the Law Show, brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I am Randy Thompson. I am the last name partner in the group. And so you got the bottom of the barrel to talk to you this segment, but I want to talk to you about negligence, specifically in the area of trip and falls and slip and falls, or what lawyers know as premises liability claims. A property owner, whether you're a private individual or a business owner of a commercial real estate adventure, a superstore, grocery store, any business that invites the public in, you have an obligation to maintain the property in a reasonably safe condition. It doesn't have to be perfect, but it's got to be reasonably safe. And you, as the owner, have to look for, be aware of dangerous, hidden conditions on a property that could cause someone to trip or get injured. And it's your responsibility as the property owner to go around on a reasonable basis every hour, every 2 hours, and look throughout the property for areas that may cause a hazard to people who are invited on your property. So I want to give you an example now, and we'll put up a still photograph of a pallet of firewood that's sitting on one of our local grocery store's sidewalks. I represent a client who ended up being injured at this property. And so I want to talk to you a little bit about looking at that photograph, understanding what that photograph shows, and then we have a different view of that same area. This was taken by the store management after my client got injured. And so in looking at those photographs, do you think there's a negligent condition on the property? Do you think there's an unreasonable hazard there that may cause someone to get injured? My answer would be yes, I do. And although I'm concerned about that crumpled edge of the sidewalk there that you can see, because clearly the store knows it's broken. Clearly the store knows it's not level. Clearly the store, in my opinion, should know that that could cause a tripping hazard, especially to an older person who may not see as well. But in this particular case, it's that row of plastic, that string of plastic that's left hanging off of the pallets and blowing in the wind. Obviously, you can't see it blowing in the wind on these still photographs, but we have videos and the plastic is blowing around, and it's clearly, in my opinion, a trip hazard. What do you all think? Do you think that's a negligent condition on the property? Do you think that's an unsafe condition on the property that may cause someone to get tangled up and hurt? Even if that answer is yes, that's a negligent condition, we still have to prove who caused the condition. How did it get there? The law in the state of Florida says that if the property owner placed it there, then they should be aware of it and they have constructive knowledge of the condition. We took the deposition of the management of the store, and they, in fact, said, yes, we put it out there. We directed that pallet and that plastic covering that firewood be out there. And so from a standpoint of how did it get there, who caused it, we think that's pretty clear. The management of the store caused it. But then there's another question. Because just because the management of the store placed that pallet there with that plastic on it, maybe the plastic was all contained at the time and it was tight around the firewood and it wasn't blowing in the wind and potentially reaching out to grab someone. So maybe the management of the store gets to say, but it wasn't a negligent condition when we put it out there. We didn't know. We didn't see any of the stuff blowing around in the wind. Well, watch this videotape. It won't take you very long. It's about a minute long, I think. That young man in the black works for the store. That young man is their employee. That young man walks by this blowing plastic probably 4 times. He had to come out right past it. He went right back in to the doors. He came back a 3rd time. Coming back the 3rd time, it looks like he's perhaps looking at trash on the ground, that piece of paper, but he doesn't do anything to pick it up. He doesn't do anything to make the property reasonably safe. He just keeps on walking. So, do I think that the store knew or should have known that a dangerous condition existed on their property? My answer is yes to that. I think they knew because when they set those pallets out there and they left them knowing that people in December would be using firewood, and they knew that that plastic would continue to get looser and looser. And despite that, they left it there. I want to show you a couple of still photos of someone who is not my client. This person, or these 2 men actually, that you see in this photograph, get tangled up in the plastic. And they get tangled up in the plastic about 30 minutes or so before my client, who ultimately comes along and gets caught in it. The store management wants to say, oh, well, those 2 men, they're the ones you should file your complaint against. They're the ones that caused this problem. That's not true. That plastic was out there blowing around, and these 2 gentlemen happened to get caught up in it, but they didn't fall. They didn't get injured. They just drove off. Well, what do you think if the store says, well, blame those men? They should have been down there. They should have picked that up. They should have called us and told us. It's not your obligation as a customer to walk around a store and tell the store what to do and how to be safe. So when you have a store and when you have employees who don't act reasonably, who don't take reasonable precautions to help and protect their customers, well, here's what happens. In this video, you will see my client and her husband coming out of the store, and at the very edge of the clip, at the very end of it, you see my client fall down. Ultimately, she had to have a complete total shoulder replacement because of the fall. Those are the damages that can happen, not to everyone. It didn't happen to the 2 gentlemen who also got tripped up in it. It didn't happen to the 10 or so other people who walked right over it and didn't get caught in it. But it did happen to my client. But now the store wants to say, oh, well, the fall is all your client's fault, Mr. Thompson. Your client is the only one that got tripped up in it that we know of. Your client is the only one that claims she didn't see it and she got hurt by it. So it's your client's fault, Mr. Thompson. So that's kind of the overview of how premises liability cases in Florida oftentimes play out. Sometimes the store management will say, oh, it was our fault. We agree. We acknowledge we should have done better, but let's blame the injured person. The significance of blaming the injured person is that if the store convinces jurors that, let's say, the fall was 50% my client's fault and 50% the store's fault, if the store convinces the jury that, well, it's all 50% her fault, then my client only recovers half of her damages. And her damages include the medical bills caused by the fall, the medical surgery, the anesthesia bills, the rehabilitation bills. My client was retired, but if she was unable to work, it would include her lost wages. But remember, if the store convinces the jury that it's 50% her fault, she only gets half of her lost wages. She only gets half of her unpaid medical bills. And that applies as well as to future damages. If she has to have future surgeries to remove certain hardware from her shoulder, or if she has to miss more time from work or attend more physical therapy. So the percentage of fault, the issue of comparative fault, is very significant. And if you are lucky enough to serve on a jury, and I do mean that, if you're lucky enough to serve on a jury and you're in a comparative negligence issue, lawyers will talk to you about that and they'll explain the significance of it. But it has real effects on a person's life. It has real effects on the store's pocketbook, right? Because if 100% of this fault is theirs, then the store owes all of the related medical expenses and lost wages. A jury could decide it's 90% the store's fault and 10% my client's fault. 95% the store's fault, 5% mine. They could decide that it's my client's complete fault, all on her own. I would think that would be an unfair verdict, but they could do it. It all depends on how the evidence comes out and who testifies, how they testify, the demeanor they have while testifying. And so all of those pieces of evidence come before a jury, and ultimately the jury is asked to decide, was the store negligent? What do you all think? I think yes. Did the store know about the condition? I think yes. Did the store leave it there for a long enough period of time that they should have known about it? I think yes. Was my client comparatively at fault? I say no. It's clear plastic blowing in the wind. She was walking with her husband, holding on to the cart. Those are things for y'all to think about the next time you go onto somebody's property and start looking around. Again, I'm Randy Thompson. I'm one of the partners at the Kerrigan Estes, Rankin, McLeod, and Thompson law firm. We are always glad to talk to you about your claims and your injuries. Sometimes we can't do anything to help you other than tell you what the law is and tell you how it applies in your case. But we're always glad to talk to you. So feel free to call us. Look us up on the web at Kerrigan.com. And we'll be back again next Sunday.